Good morning, Mr. Martinez. Sir, you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you
Notice here, this is more than just a traffic ticket. Driving with a suspended license can land you in jail, and the judge is laying out Miranda rights just like in a criminal case. Quick question for you all. Do you think the punishment should be this harsh for a suspended license, or is it justified?
cannot afford one, one will be appointed to you, sir.
On April 12, 2025, officers observed a motor vehicle failed to signal a lane change. Officers also observed the motor vehicle's registration had expired in 2022. There was also unconfirmed insurance. Traffic stop was conducted. Defendant was identified by his Texas ID card. Defendant stated he did not have a driver's license nor proof of financial responsibility. Officers learned the defendant was not an eligible driver due to a license suspension back in February of 2024. Officers learned the defendant had 5 prior convictions for failure to obtain liability insurance on his license. Officers asked the defendant if he was aware of his driver's license was suspended, and he advised he was. However, he did not know how it was suspended, saying he was working on his SR-22 and reinstating his driver's license.
Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a
Wow, did you catch that? The judge is making it crystal clear, and no driving under any circumstances. He even used the burning building and kittens example to drive the point home. This isn't just courtroom drama, it's a warning with teeth. What do you think? Is the judge being too extreme here, or just protecting the public?
condition of your bond not to drive. I don't care what you have to do in this life. I don't care if there's someone having a heart attack and you have to go save them. There's a burning building and you have to save 50 kittens. I don't care. If you don't have a license and liability insurance, you're not allowed to drive. This is an affidavit that you're going to be signing with me. And if I find that you do, every single time you drive, it's a contemptible action, punishable by up to 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
If you want to drive, go get a license, get liability insurance, and I will be doing backflips. So happy I will be to take this off. But if I find that you do, it's really not going to go well for you. Do you understand?
Yes, sir.
You have the ability to hire a lawyer.
No.
I can have you fill an application. I'll take a look to see whether you qualify. Deputy Miranda will give you an application. I'm going to have you come swear to us that you're not going to drive. I'll get you to Victoria Sign and Reset, and then we'll have you take a seat. Please.
You're giving spot law conditions for everybody?
Yeah. Yeah. With both. No driving and then no without insurance as well. Ma'am, you're charged with 2 cases. You're charged with criminal mischief, and you're also charged with interference with the emergency request for assistance. On the criminal mischief, you're facing up to 6 months in jail and a $2,000 fine. And on the interference case, you're facing up to a year in jail and or a $4,000 fine. I also see she has an open warrant.
Yes, Your Honor. I see that as well.
You also are charged with, I guess, the following day, you picked up a terroristic threat. On that case, you're facing up to 6 months in jail and or a $2,000 fine.
I do that, Tony.
First, we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to
I
you.
get that, Tony.
Let's do probable cause and then we'll.
On April 13th, 2025, officers were dispatched to a disturbance. Dispatch stated that the defendant knocked the complainant's phone out of her hand and then left the location. Officers made contact with the female matching the description given by dispatch. The female stated that she was the victim, but she was not talking without a lawyer. Defendant gave name and date of birth, but would not provide an ID card. Defendant was detained and taken back to the incident location. Complainant stated she reported a criminal mischief on the defendant the day prior. Complainant advised to dispatch that he would later call back and report the incident, which he received video of the incident proving that the defendant had damaged his vehicle. Complainant advised today he went to the store, and when he returned, the defendant was on his porch. Complainant asked the defendant, "What are you doing here?" After you broke my window of the vehicle of my vehicle. Complainant advised he told the defendant just to sit there while he called police. Defendant then left, but returned while he was on the phone with dispatch. Defendant knocked the phone out of his hand and caused damage to the phone. The value of the phone was $300.
And what about the terroristic?
So the terroristic threat, Your Honor, and this is the same complainant. On April 15th, officers were dispatched to a telephone harassment. Upon arrival, officers spoke with the complainant. Complainant stated that he had received a phone call from the defendant via a Google phone number threatening to shoot up her home. Complainant stated she was confident the caller was the defendant and expressed her desire to pursue criminal charges. Further investigation revealed that the defendant had been arrested at the same location on April 13th for interference with an emergency call and mischief. She was out on bond for that incident.
Should be given conditions not to go back.
Let me check here.
Ms. McKnight, I'm going to find that there's probable cause to go forward with the case. I don't want you to have contact with this person.
It's not for them. I'm hurting about that person.
I don't want you to have contact with this person. Do you understand? Are you sure? You understand?
Yes, sir.
Okay, I don't want you to go where this person lives. If you do, it's not going to go well. I will revoke your bond, put you in jail. Do you understand?
Yes, sir. I have evidence for all that.
And I'm going to give you a lawyer today. I know that there's two sides to the story. You can give your side of the story you can give your side of the story to the lawyer, but I don't want you to have contact with this person. That's it. Do you understand?
So when it comes down to the child, do I have to come back to court just to get in contact with him?
I don't want you to go to his house.
No, I'm talking about, do I have to come to court so I get in contact with him because we have a child?
We'll figure that out. Let me get you the lawyer and then we'll figure that out. But just don't go to the person's house. Don't have contact with him. Don't call him. Don't use anybody else's phone to contact him. It's not going to go well.
Yes, sir.
You need to understand that if I revoke your bond in this case and I set them at $5,000 to $10,000 and you don't have anyone to post those bonds, you will be stuck in there until these cases are over. Do you understand?
Yeah.
Okay. Deputy Miranda, you mind? You know what? Don't even worry about it. I'm going to appoint you a lawyer today. I'm going to have you sign a reset with Victoria, and then we'll have you take a seat in the jury box while I find you a lawyer. Don't leave until you sign our bond conditions. Okay. Mr. O'Neill. Morning. Sir, you're charged with terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. All right.
Good morning, Judge. Just 1 second, pulling up right now.
Okay.
So,
I thought I was supposed to have an attorney here today.
Did you hire one?
No, the judge that I talked to said that I could have.
That was for purpose of magistration, but it doesn't carry with you until the end. You don't have a lawyer at this time.
all right, Judge. On April 12th, 2025, officers responded to a family disturbance call in Harris County, Texas. The officer ID'd the complaining witness by their Texas ID card. The complaining witness stated that the defendant threatened to shoot her. The complaining witness ID'd the defendant by his Texas driver's license. The complaining witness stated that she is the defendant's daughter and they all live together in their grandfather's residence. The complaining witness stated that the defendant threw her clothes outside. The complaining witness stated she asked the defendant to go get them. The complaining witness stated that the defendant stated, "I have something else for you," and then took his hand and pointed it at the complaining witness, stating, "I'm going to shoot you." Complaining witness stated that they were in fear due to multiple guns being in the house and the defendant having a violent history. The complaining witness stated she observed the defendant holding a black long gun. The officer detained the defendant. The defendant refused to ID himself, repeatedly stating, "What is going on?" The Miranda rights were read. The defendant denied all allegations and stated his daughter.
This is the third case we've seen back to back where bond conditions are the real game changer. Notice how the judge keeps stressing no contact and no weapons. That's because violating bond conditions often lands people right back in jail, sometimes faster than the original charge. Have you ever heard of someone breaking bond conditions and regretting it?
Complaining witness was lying. Defendant advised that he hadn't seen the complaining witness all day long because she was at the hospital visiting her mother. The officer inquired about this, and the complaining witness stated that she did not go to the hospital. It was only her grandfather who went. The complaining witness stated that she was home and the defendant did see her and threaten her.
All right, Mr. O'Neill, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. These are your bond conditions. If you violate these conditions, I will revoke your bond, put you in jail.
Absolutely.
Do you understand?
I don't have.
Just don't say anything at this point. Just don't have any weapons, don't have contact with this person. There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, they will potentially file additional charges against you. Do you understand?
Yes.
Okay.
What about the house? That's where all my stuff is at.
What I'm going to do is I'll appoint me a lawyer today. You can talk to the lawyer about what's going on, but I'm going to do everything in my power to protect everybody in this at all costs. You understand? Okay. So look,
She can go wherever she wants, but I'm just asking.
let's do this. Let me appoint you a lawyer. You can talk to the lawyer and we can go from there. Now is not the appropriate time to go through this.
I've been staying at a shelter
Okay, hold on.
and
I already have an application. So Vic, do you mind appointing him? I already have an application on file. For now, what I'm gonna have you do is I'm gonna have you sign a reset with Victoria while you take a seat in the juror box while I find you a lawyer. We'll have you talk to this person and we'll go from there.
did the reset happen in a few days.
We usually do like a month.
Months.
I'm gonna have you talk to a lawyer today. Good morning, Mr. Schaefer. Sir, you're charged with aggregate theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. All right.
Thank you, Judge. The officer made contact with the loss prevention officer of O'Reilly's Auto Parts, who stated that he received an anonymous online tip about a possible theft regarding one of the employees from the 3498 FM 528 location. That's an address. The tip stated that the defendant had made 2 fraudulent returns and kept the money from them. The first return was back on August 2nd, 2024 for $316.50 for three brake rotors. The complaining witness was able to contact the customer and they advised they did not return the rotors. The other return was on January 16th, 2025 for $179. The complaining witness contacted that customer and they also advised that they did not return the product. The total of the 2 returns was $495.50. The defendant admitted to the theft in a written statement. Complaining witness provided the 2 fraudulent receipts and listed on each was Schaefer's unique counter number.
Okay. Mr. Schaefer, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to have contact with this O'Reilly. There's not a specific complaining witness, right? So I'll just go into O'Reilly's. Do you understand?
Yes, sir.
Okay, if I find that you do, if I find that you pick up a new case, it's not going to go well. Do you understand?
Sure.
Do you have the ability to hire a lawyer?
Sure, I do that.
Okay, we can have you fill out an application. I'll look to see whether you qualify. Deputy Miranda is going to give you an application. I'll have you go to Victoria, sign a reset. We'll have you take a seat. We're losing spots.
I only got one more minute and I'm supposed to come in.
Okay, well, there's one.
Bond conditions.
Okay, so we'll do all that. We'll have you take a seat there and then let me start. Okay, please.
I'll just call up the next one.